Hello and welcome to Narayana IS. I'm Pratik, faculty for Polity, International Relations and Security. Students, how are you? I hope you're doing great. I hope you're working towards fulfilling your dream. You're doing everything that requires to clear the examination, right? So make sure you work extremely hard and ensure that you fulfill your dream of clearing the examination and finally contributing to the growth of our nation. Please remember that contributing to the growth of your nation should be your ultimate motivation, not power, not nothing. Growth of the country should be your ultimate motivation. Right. So yesterday we know that we discussed a few topics from the theme center and the state relations. I hope and I expect that you must have downloaded the notes of the topics that we discussed yesterday and also revised the topics that we covered yesterday. I hope, right? So today we'll be starting with a new theme, and the new theme is judiciary. But before we start with the topics that we shall be discussing today, I have an announcement to make. So Narayana IS soon is going to launch 1 year and 2 year Prelims cum Main integrate course. All those students interested can scan the QR code available on your screen and fill in the required details. Our team shall get back to you at the earliest, right? So on this note, let us see the topics that we shall be discussing in today's lecture. The first topic is on the collegium system. The second one talks about the All India Judicial Service. The third, power of the Supreme Court under Article 142. Then we understand the concept of contempt of court. The fifth, bail, the types of bail, the provisions under which the bail is granted. Sixth, advocates not liable. So in this we shall discuss what is Consumer Protection Act, because the advocates are not liable under the act. Then again, the seventh topic we shall be discussing the power of Supreme Court, that is the curative power of the Supreme Court, which is different from the review power as well as the special leave petition. The eighth topic talks about the judgment of the Supreme Court in the VVPAT case. And finally, in the ninth, we shall be discussing the concept of arbitration. So these are the 9 topics that we shall be discussing today. Make sure you're fresh, make sure you have pen and paper to jot down the notes, and towards the end of the lecture, make sure you're downloading the notes from the description and revising all the topics that we're discussing on a day-to-day basis. Right, on this note, let us get started with the first topic, the topic being collegium system. Now, collegium system, it deals with the appointment of the Supreme Court. That's the reason we are discussing the topic, because of the relevance of such topics for the examination. See, the appointment of the Supreme Court judges questions have been asked. The question was asked in the year 2012. That's the reason such topics are important for the examination. And what is the context? The collegium system is in the news. Why? Due to the recent proposals aimed at reforming the judicial appointment, which means there's a growing debate. The experts are calling out that reforms in the appointment of the Supreme Court and the High Court judges should happen at the earliest. Reforms is overdue, and it is important that there should be reforms in the appointment procedure of the Supreme Court and the High Court judges. Now, first and foremost, let us try to understand what is collegium system. What is the collegium system? Now, collegium system is nothing but it is a method. It is developed by the judiciary in our country, and what is the purpose? The purpose is appointment and transfer of not only the Supreme Court but also the High Court judges. So please remember, collegium system refers to the appointment and transfer of Supreme Court and the High Court judges, and not the lower judiciary. Now please remember, the collegium is not mentioned in the constitution. Another very important point for your prelims. Not mentioned, which means it was evolved through a series of Supreme Court judgments. Which means this came into being through the evolution of the Supreme Court judgments, which we are going to discuss. The key aim of this or motive of this, collegium system is to ensure what? Judicial independence. What is the purpose? Judicial independence. How? Which means neither the legislature nor executive will have a say in the appointment of Supreme Court or High Court judges. Which means here the judges will appoint themselves. The judiciary will be responsible for the appointment of Supreme Court and High Court judges. The members of the legislature and executive will not be a part of the appointment process. This is what we understand by the term collegium system. Let us discuss the constitutional provisions for the appointment and transfer of the Supreme Court and the High Court judges. Right? Now, please remember the Constitution, it provides a legal framework for the judicial appointments. It does not mention the collegium directly, but it mentions the legal provision, or let's say the constitutional provision. For example, Article 124 Clause 2. This article, it states that the judges of the Supreme Court are appointed by the President. The judges of Supreme Court are appointed by the President of India after consultation with the Chief Justice of India and other judges. Who appoints the judges of the Supreme Court? President, after consulting the Chief Justice and other judges as necessary. This is what Article 124 Clause 2 states. Then another section, that is another article, Article 217 Clause 1. This talks about Supreme Court judges, this talks about High Court judges, which means the High Court judges, again they are appointed by the President of India. How? After consulting the Chief Justice of India, the Governor of the state, also the Chief Justice of that High Court. Which means, let's say, if a judge in the Bombay High Court needs to be appointed, then the President appoints after consulting the Chief Justice of India, the Governor of Maharashtra and the Chief Justice of the Bombay High Court. And then we have Article 222 Clause 1. This states that President has the power to transfer the High Court judges, again here after consulting with the Chief Justice of India. This deals with transfer. Who transfers? President. Again here, if you see in each of these clause, the consultation with the Chief Justice of India is mandatory. Then the question is, how did the concept of collegium evolve or came into being? There are 4 cases that you need to understand. These cases are very, very, very important. So the collegium system has, evolved through a series of these landmark Supreme Court judgments. Now these rulings, they interpret the word consultation. Now the key word is, now in the earlier constitutional provisions, we repeated one word, that is consultation. Consultation with the Chief Justice of India. Now these rulings actually they interpreted the word consultation in the constitution and gradually shifted the power of appointments from the executive to the judiciary. How? Let us understand. Let us discuss the first judge's case. First judge's case, 1981, SP Gupta versus Union of India case. Now in the first judge's case, the Supreme Court held that the word consultation does not mean concurrence. What? Consultation does not mean concurrence. Does not mean concurrence, which means this allowed the executive to have a final say in the appointment. The opinion of the judge, the Chief Justice of India, could be overruled for any reason. And this interpretation remained in place for the next 12 years until 1993, which means here even the president, of course, the president will act upon the aid and advice of the Council of Ministers, which means the executive is having a final say in the appointment of Supreme Court and the High Court judges. Why? Because the word consultation does not mean concurrence, which means the president is free. The president can also override the opinion of the Chief Justice of India. And here we see that the executive had a say in the appointment of Supreme Court and the High Court judges until the second judge's case in the year 1993. Now, in the second judge's case 1993, right, this case actually made a major shift. The Supreme Court ruled that the word consultation means concurrence. Here the Supreme Court said that consultation means concurrence. And this actually gave the judiciary a dominant role in the appointments. This judge's case, the second judge's case, introduced the concept of collegium. Where the Chief Justice would form an, let's say, an institutional opinion in consultation with two senior most judges of the Supreme Court, which means whenever the Chief Justice of India would give an opinion to the President, the Chief Justice of India has to consult two senior Supreme Court judges. This is what the Supreme Court remarked in the year 1993. Then came the third judge's case 1998, right? Now, in response to a reference from the President, the Supreme Court expanded the collegium. Which means it held that for the Supreme Court appointments, the collegium should include the Chief Justice of India and four senior most judges. In this case, the collegium was expanded, which means now we have the CJI plus four senior Supreme Court judges. In the second judge's case, Supreme Court Chief Justice of India plus two senior most judges. But in the third judge's case, for the Supreme Court, this is for the Supreme Court, and for the High Court, the collegium would comprise of Chief Justice of India plus two senior Supreme Court judges. And even if two judges disagreed with the recommendation, it was not to be sent to the government. It was not to be sent to the government. So for Supreme Court, CJI plus 4, for High Court appointment, High Court judges appointment, CJI plus 2 Supreme Court judges. This was the outcome in the third judge's case given in the year 1995. And then came the fourth judge's case in the year 2015. Now, Parliament in the year 2015, it passes 99th Constitutional Amendment Act, 99 Constitutional Amendment Act, and the name of the act was NJAC, National Judicial Appointment Commission. This NJAC, it replaced the collegium. It replaced the collegium. I hope you understood what is collegium. Now a system came altogether to replace the collegium system. Now this NJAC, this commission included members from the judiciary as well as the executive. Again, an effort was made to bring the executive in the commission, and these executive members will be responsible for the appointment of Supreme Court and High Court judges. However, this NJAC Act, this 99 Constitutional Amendment Act, was declared unconstitutional. It was declared unconstitutional by the Supreme Court. Why? Because it violated the basic structure of the Constitution. And what is the basic structure? Judicial independence is part of the basic structure of the Constitution. It said that the NJAC system is incorrect, is unconstitutional, And again, in this case, the collegium system was restored. The collegium system was restored, which means to this date we have a system where for the Supreme Court judges we have Chief Justice of India plus 4 senior most judges. For the High Court judges appointment we have the Chief Justice of India plus 2 Supreme Court judges senior. I hope you understood the collegium system, right? Key features of the Supreme Court. This is the key feature of the Supreme Court or the collegium system as it is practiced at present, right? Any questions? Please let me know in the comment section. Okay, let us discuss the procedure for judicial appointment. Now see here again, for appointing Chief Justice of India, the President appoints the CJI and other Supreme Court judges. The outgoing CJI recommends his successor, outgoing. The seniority principle is followed as well as a well-established convention, which means only the senior most judge of the Supreme Court becomes the Chief Justice of India. Now, this convention of appointing senior most judges was, violated twice in the history of judiciary in the year 1973 and 1977. But post 1977, the convention of appointing the senior most was continued. And for appointing other Supreme Court judges, again the collegium system comes into practice. CJI plus 4 senior most judges. For appointing Chief Justice of High Court, the President must consult CJI plus the Governor of the concerned state. So again, this is something that we already have discussed. So let us start with the second topic. And what is the second topic is about? All India Judicial Service. The President of India recently supported for the implementation of All India Judicial Service. This as a means to improve diversity within the judiciary by boosting the presence of underrepresented social groups like the SC, the ST, the OBC, women. We know about the All India services. Which are the All India services? The IS, the service that you all are preparing for, you are working hard. Then we have Indian Police Service, Indian Forest Service. These are the 3 All India services. These are the 3 All India services. UPSC conducts the examination for these services along with other services as well. On the same lines, we are planning. India is planning for the All India Judicial Service on the lines of All India services. Now, question on the question on the services are often asked in the examination, as it was asked in the year 2017. Now, this is a question on the National Career Service. A question on All India Services, All India Judicial Service can be asked in the examination. Now, first and foremost, let us try to understand what exactly is All India Judicial Service. All India Judicial Service. Now, the All India Judiciary Service, it is a proposed system, which means it is not a system that is practiced, it is a proposed system. In this system, the judges will be recruited at the level of district and additional district judges across the country. District and additional district judges at the district and additional district judges across the country. Now, the idea is to have a centralized recruitment process similar to the UPSC, where the selected candidates are appointed to the judicial posts in various states, like it is for the All India Services, IS, IPS and Indian Foreign Service. The purpose is to bring uniformity across the country, transparency in the appointment and efficiency in the judicial appointments. The 42nd Constitution. Now you may wonder what is the present system followed. Don't worry, we'll discuss the present system. But the purpose is to make the appointments not for the Supreme Court and High Court judges. Please keep this concept, keep this point very clear in your mind. For Supreme Court and High Court appointments, we have the collegium system. Here we are talking, or here we are discussing the appointment of district and additional district judges across the country. The 42nd Constitution Amendment Act, it gave Parliament the power under Article 312. The Constitution has given the Parliament the power to create All India Judicial Service, or rather All India Services. So who has the power to create All India Services? It is the Parliament that has got the power under Article 312 Clause 1. And the question is, why was the All India Judicial System or Service proposed? Why is it that this system is proposed? Now, this system was proposed for the first time by Law Commission. By the Law Commission in its report in the year 1958 and 1978. Why? To address the long-standing challenges in the judicial system. Long-standing To address the challenges in the judicial services, the Law Commission recommended the creation of All India Judicial Service. One of the key reasons was the inconsistent pay and service conditions, right, for judges across the states. For example, an IS officer, no matter which state he is serving, for a particular post he is handling, the salary is the same, the working conditions are the same, but it is not with respect to judges and additional judges. And that's the reason a centralized service would help standardize the salaries and also the work environment for the district judges. Another goal was to speed up the recruitment process to reduce the vacancies in courts. Now we have heard so many times about the vacancies in courts. It also aims to, to ensure uniform training and standards for judges throughout India. Uniform training and standards, like on the lines of All India Service again. We know that the aspirants who clear the examination, they head to Labasna. From Labasna, they go to the respective places. In the sense the headquarters of or the training place. Like for example, the IPS people go to Hyderabad at the National Police Academy. So here, if you see, the training is uniform and the training standard is uniform across the country. And the purpose is to improve the quality of justice. That's the reason uniform training is required. And also, All India Judicial Service was seen as a step towards reducing the huge backlog of cases, especially in the lower courts. How? By filling up the vacancies and thus strengthening the manpower in the lower judiciary. So these are the problems that is still existing in the lower judiciary. To find the solution, the Law Commission recommended that All India Judicial Service be created for the recruitment of judges at the district level across the country. Yeah. Talking about the constitutional provisions for All India Judicial Service, right? Constitutional provisions. Now, the basis of All India Judicial Service, right, is mentioned in Article 312 of the Indian Constitution. It allows the Parliament to create an All India Judicial Service similar to the All India services. Now, according to Article 312, right, 312 Clause 2, right, the All India Judicial Service can only include positions equivalent or higher than that of district judge. Position equivalent or higher to that of district judge. It cannot include posts below the rank of district judge. Although the constitution is allowing for the creation of All India Judicial Service, it has not been implemented. Why? Because certain procedures and let's say the approvals are still pending. Which approvals we'll discuss. And if All India Judicial Service has to be created, what is the procedure? See, questions pertaining to all these dimensions can be asked in your examination. That's the reason understanding these points are very, very important. The first step to create All India Judicial Service, a resolution should be passed. First, the resolution should be passed in the Rajya Sabha. The resolution needs to be approved by two-thirds majority, of the members who are present and voting. Now, once it is done, the Parliament can make necessary amendments to Article 233 and 234 of the Indian Constitution, which deals with the appointment of judges in the lower judiciary. This deals with the appointment of judges in the lower judiciary. Now, please remember, these changes require only simple majority. It does not require special majority. After these amendments, the Parliament can use the All India Service Act of 1951 to regulate the recruitment and service conditions for the All India Judicial Service. Now, importantly, it is important to remember that the entire process does not require a constitutional amendment under Article 368, which means All India Judicial Service can be established through ordinary legislation, through ordinary law, which requires a simple majority. This is how All India Judicial Service can be established or created. Which means you must have understood by now that the All India Judicial Service is meant for the appointment of, or let's say for the appointment of positions at the district level, district judge level, or positions higher than the district judges level, not below the level of district judge. Which means the appointment procedure for appointing a district judge will be uniform across the country. Which explains that as of now, at present, the recruitment process is not uniform across the country. Simple. That's the reason we are proposing. The Law Commission had proposed that All India Judicial Service must be created. The question is, what is the present system now? What is the present system to the judicial appointments, especially the lower judiciary? Now, please remember, currently, the judges for the district courts, are appointed through examination conducted by the State Public Service Commission. Right? Now, this commission, in coordination with the respective high courts, which supervise the subordinate judiciary in each state. Now, who supervises the subordinate judiciary? It is the High Court of every state. So, the State Public Service Commission, in coordination with the respective high court, will recruit the positions in the district court. Now, there's a written examination. After the written examination, the candidates who clear the mains examination, written examination, have to go through an interview process, and this interview process is conducted by the High Court judges. Interview is conducted by the High Court judges. So, first written examination, then interview by the High Court judges. This is for the district courts. Please remember, district courts. And then for the lower judiciary, that is below the district judge level, the appointments are made through the provincial civil services judicial examination. For all the positions below the district courts, the examination is conducted by the provincial civil service judicial examination. This again is held at the state level. I hope you understood this is the present system, which means every state has this state public service commission. They have their own rules and regulation. Based on that, district judges are appointed. Now, once the All India Judicial Service is created, these people will not have any power, which means the state power will be taken away. This brings us to the question why All India Judicial Service has not been implemented yet. If you understood the argument discussion so far, then you should be in a position to understand why so far All India Judicial Service has not been created. Now we know that this All India Judicial Service has been proposed for from many years, and even the constitution supports the creation of All India Judicial Service, but this has not been implemented or created. Why? Because there is no consensus among states. The judicial appointments, we have discussed that below the level of High Court fall under the state list in the 7th schedule of the Indian Constitution. This is below the High Court, which means the lower judiciary, which means states have the power to regulate the appointment for the lower judiciary. And the concerns are that the state government would lose the control with respect to appointment, language, and the local law compatibility. Now, as of 2023, there is still no agreement among all the states or key stakeholders with respect to creating All India Judicial Service. The crux is the state governments, the state would lose the power with respect to appointing the judges at the lower judiciary, and that's the reason the states are not supporting this concept of creating All India Judicial Service, because we know that All India Services, in the chapter on federalism, we discussed, or we have the difference between the federal features and unitary features. All India services fall under the unitary features, and we know that India is a federal country. India is a quasi-federal country, which means center and the states both have the power, but the more powers are inclined in the hands of the center. So creating All India Judicial Service, which means vesting more and more powers in the hands of the central government. I hope you understood the second topic as well. Let us proceed towards the third topic. Article 142 of the Indian Constitution. Now the Supreme Court invoked Article 142 in the Chandigarh mayor election case to overturn the election results. Right? This is not important. What is important is Article 142. Now question on Article 142 has been directly asked in the examination in the year 2019. What is Article 142? Let us understand what is Article 142 of the Indian Constitution. Now, Article 142. Now, Article 142, it gives a special power. It gives a special power to the Supreme Court to ensure complete justice. This is a keyword that you need to remember. Complete justice in any case. This means that if applying a law strictly would result in unfairness, If applying a law would result in unfairness, the court can go beyond the written law to deliver justice to the aggrieved party. This power acts as a flexible tool in situations where the existing legal system does not provide a clear solution. At times, the laws framed can be or can result in injustice. That's the reason the idea behind Article 142 is to make sure that justice is not denied just because the law is silent or incomplete in a particular situation. Orders passed under Article 142 of the Constitution are enforceable throughout the entire country, which makes it strong instrument of judicial intervention. Whenever the Supreme Court feels that there's a grave injustice happened, then under Article 142, Supreme Court has a power. Supreme Court can actually take the power, or let's say if a matter is pending before any lower judiciary and the Supreme Court understands that there's a grave injustice happened, then the Supreme Court can take up the matter and can give justice. This is the power of Article 142. Again, the constitution, there are constitutional provisions supporting this idea, right? Article 142, which means it works with other constitutional ideas. For example, Article 32, we know that under Article 32, people have the right to approach Supreme Court directly. What? For the enforcement of fundamental right. Then we have Article 141 of the Indian Constitution, which makes it binding on all the courts in India to follow the decisions of the Supreme Court. It is binding on all the courts. Then we have Article 136, which allows the court to grant special leave to appeal. Special leave to appeal in cases that may not be otherwise appealable. Together, Article 32, Article 141, Article 136, these provisions strengthen the Supreme Court's authority and support the use of Article 142 of the Indian Constitution when required, which means when grave injustice has happened. However, this concept of Article 142 has been linked with the concept of judicial activism. Judicial activism is a concept where the courts are seen as stepping beyond its usual and sometimes entering into the law-making domain. Who makes the law? Legislature. Article 142 is linked with judicial activism, which means at times the work that should be done by the legislators, the judiciary is actually doing it. And this has raised concerns in the past about maintaining a balance between judiciary and legislature. But at times when the legislature, parliament fails to take an action, the judiciary is forced to take action. Let us discuss few notable cases involving 142 where the Supreme Court had to do a work which is actually supposed to do by the legislature. Now, one of the earliest use of Article 142 was in the Union Carbide Corporation versus Union of India case in the year 1991, when the Supreme Court ordered the Union Carbide Company to pay compensation to the victims of the Bhopal gas tragedy. We know Bhopal gas tragedy. Here, the Supreme Court ordered the company to pay compensation. This case showed how 142 could be used to enforce justice on a large scale when the legal framework is insufficient. Given the way or given the people surrounding the factory and the way they suffered, the Supreme Court realized that these people have met great injustice, and that's the reason to dispense justice. Supreme Court invoked the power under 142 and ordered the company to provide compensation. Then in the liquor sale ban case, right? In this case, the Supreme Court banned the sale of liquor within 500 meters of national and state highways. Why? The purpose was to reduce drinking or drunk driving. This was another example in the court taking, or this was another example of the court taking steps in public interest under Article 142. Actually, this is a decision taken by the legislature, but when the judiciary is, when the legislature is silent, then the judiciary has to step in. Again, third case is the state of Karnataka versus Uma Devi in the year 2006. The court clarified that using Article 142 must follow the principles of law. It stated that the court cannot use its power to regularize illegal appointments just out of sympathy, as that would overstep into the area which is actually reserved or confined within the legislature. Right? So, it can be only invoked when the Supreme Court realizes or understands the intensity of injustice which has been uh, which has taken place. I hope you understood the concept of Article 142 of the Indian Constitution. Let us proceed towards the next topic, which is the contempt of court. The Jharkhand government has filed contempt against the center for dealing the appointment of a new Chief Justice to its High Court as recommended by the Supreme Court's Collegium. I hope we know what is Supreme Court's Collegium. We have discussed in the first topic. So, questions on contempt of court have been asked as it was asked in the year 2022. This is a question on the civil contempt as well as the criminal contempt. The Contempt of Courts Act 1971. That's the reason we are discussing this question. The question is, what is contempt of court? Now, contempt of court is a legal mechanism. It's a legal mechanism, or let's say it's a legal tool that helps protect the authority and dignity of the judiciary. It ensures that courts can work independently without being disrespected or obstructed by individuals or institutions. Now, the main purpose of the contempt, the power of contempt, is to prevent actions that can lower the public's respect for the judicial system or interfere with its proper functioning. If someone disobeys a court order, or let's say shows disrespect towards the judges or tries to influence a case, then the court can take action under the contempt laws. Under the contempt laws. Again, the constitution is backing the concept of contempt, and you will understand the constitution and legal provisions that backs the concept of contempt, that is punishment. The power to punish for contempt, it actually comes from the constitution provisions and also a law passed by the parliament of the country. Article 129 and Article 215 of the Indian Constitution recognize the Supreme Court and High Court, the Supreme Court and the High Court as court of record, as court of record, right? Which means it gives them the authority to Supreme Court and High Court, the authority to punish anyone for the contempt, which means disrespecting judges, influencing a case, or let's say interfering with the judicial mechanism. Then we have Article 19 Clause 2 of the Indian Constitution, right? This Article 19, it actually lists the contempt of court as a reasonable restriction of the freedom of speech and expression. Reasonable restriction on the freedom of speech and expression, which means that while people have the right to speak freely, they cannot use that freedom to insult or let's say interfere with the judicial mechanism. Having the right to speak freely, that does not mean that you actually lower the dignity of the judiciary by criticizing the judiciary without any substantial evidence. And then we also have the Contempt of Court Act. This is a legal mechanism. It's a main law that explains what contempt is and what punishments apply in case of contempt. It divides the contempt into two broad categories. One is the civil contempt. Civil contempt, which means you are actually disobeying an order of the court. Second one is criminal contempt. This is disobeying the order of the court. Criminal, which means you are actually doing something that is actually lowering the dignity of the court, or you are scandalizing the court, or let's say you're obstructing the justice delivery mechanism. So civil and criminal, please remember the difference between these two terms because it can be asked in the examination. And what is the punishment? This act actually lays the punishment. The punishment is jail for 6 months or fined up to 2000 or both. However, a significant amendment was made in the year 2006, which allows a person to defend themselves by proving that their statement was actually based on truth and it was made in good faith, which means a person on whom contempt this case is actually charged, this person has a right to defend himself. Even then, the court will punish only if it believes that the action has substantially interfered with the judicial mechanism. The amendment actually allows a person who is accused to defend himself by stating that whatever he has, let's say, whatever he has spoken or acted was done in good faith, or the criticism that he or she criticized was substantiated by, let's say, evidence. Now, does this mean that we cannot, criticize the judiciary, or judiciary is free from any criticism, or everything that happens in the judiciary is perfect, picture perfect? Absolutely. The judiciary again is one of the most corrupt systems, unfortunately. That's the reason we have the right to criticize judiciary, which means certain actions, even if they involve the courts, are not treated as contempt if someone provides a fair and, let's say, accurate report of what happened during a court proceeding. That is not contempt. If you criticize the judicial mechanism, it cannot be, or let's say, contempt. There will be no punishment. Also, if a case has been decided and someone makes a fair criticism of the court's judgment, you can also criticize the court's judgment, but you cannot disrespect the judgment of the court. This again will not be considered contempt, which means this actually helps to ensure that the public discussion and accountability is not silenced. But the condition is the criticism should be respectful and it should be well reasoned. So you have the right to criticize the judgment of the court. You have to obey the judgment. You have the right to criticize. The criticism should be respectful. It should not draw, or it should not be rebuked by the court. This is the concept of contempt of court. I hope you understood the concept of contempt of court. Let us proceed towards the next topic. The topic talks about bail and the provisions. So in this case, in this topic, we'll understand what is bail, the types of bail, the types of offences, right? Now, first and foremost, what is bail? Now, Question is, what is bail? Now, bail refers to the temporary release of a person accused in a criminal case. It's a temporary release of a person who is actually accused in a criminal case. It allows them to remain free while the court is still hearing the case. A person has been accused, a person has not been yet declared guilty, he is accused, there is trial going on. That's the reason bail allows a person to be free until the court gives a judgment. It does not mean that the person is declared innocent, neither it means a person is declared guilty, but it protects the liberty of the person until the final judgment is given. Bail also involves a financial or let's say personal security, which means whenever the court orders a person to appear before the court, he has to, which means a person who has been granted bail, he should give assurity to the court that whenever required, he has or he needs to be present before the judiciary, before the court. I hope you must have seen bail, the concept of bail in many movies. What are the types of bail? There are three main types of bail depending on the stage of the criminal case. Depending on the stage, at which stage the case is, the extension of the bail is determined. One is regular bail, interim bail, and anticipatory bail. Now, what do you mean by regular bail? Now, this regular bail is given to someone who has already been arrested or is in custody. Arrested or who is in custody. It allows a person to be released while the case is still ongoing. He is arrested, now person is set free for temporary time. Now, interim bail is short-term relief. Short-term. It's a short-term relief granted to an accused person when the main bail application is still being decided, which means a person has applied for a bail, it's taking time for the bail or let's say to be heard by the court, and in the meanwhile interim bail is given. It prevents immediate arrest or let's say continued detention until the final decision is made. Then we have anticipatory bail. Now, this is applied before a person is arrested. A person is not arrested. Before a person, let's say for example, I feel that the police may arrest me. So, what I do is, I go to the judiciary and I take anticipatory bail. It's a safeguard for individuals who believe they might be arrested for a non-bailable offense. This is very, very important. Non-bailable offense. For bailable offense, anticipatory bail is not valid. Now, this type of bail is granted by either a session court, or high court. Please remember that anticipatory bail is granted to only non-bailable offense. We will discuss the difference between bailable offense and non-bailable offense. Now, let us discuss the legal framework, the laws which actually allow for bail in our country. The word bail is not defined in the Code of Criminal Procedure. Please remember, the word bail is not defined in the CRPC. We know that CRPC is replaced by BNSS, right? But the procedures and rules for granting bail is clearly mentioned in CRPC. Word bail is not defined. Please remember, this type of questions can be asked in the examination. The word bail is defined, not defined. So, the word bail is not defined in the CRPC, but the procedure and rules for granting bail is clearly mentioned in the CRPC. For example, Section 2 of the Indian Penal Code. Now, IPC, we know, IPC has been replaced by the Bharatiya Nyaya Sanhita. This Section 2 of the Indian Penal Code refers to bailable cases or let's say bailable offenses and non-bailable offenses. Which are the offenses against which bail can be granted and which are the offenses against which bail cannot be granted? So let us discuss the difference between, uh, bailable offences and non-bailable offences. Now, please remember that bailable offences are considered less serious and usually carry a punishment of, let's say, 2 or 3 years. The accused person against whom, against whom a case has been charged has the right to get bail, and even the police can grant bail at the time of arrest. Bail must be given if the investigation is not complete within the allowed time, if the trial is not concluded within 60 days, or if after trial there is no strong reason to believe the accused is guilty. Accused is guilty. Again, I repeat, the accused in such case, right, in case where a person has been, let's say, charged under the bailable offense, right, he has the right to get bail, and even the police can grant bail during the time of arrest. Now, please remember, if the investigation is not complete, then the bail must be given. If the trial is not completed within 60 days, for example, a person has, let's say, been charged of, let's say, robbery. A person has been charged of robbery and the investigation has not been completed, let's say, for 3 months, or the trial is not concluded, and a person is made to suffer in the jail. During such case, bail is granted to a person because there is a strong reason to believe that this person has actually not stolen anything. Non-bailable offense. Now we'll understand non-bailable offense. They are more serious and the punishment is usually, let's say, more than 5 years. In these cases, bail is not a right but is given at the discretion of a court. In the bailable offense, bail is your right. In the non-bailable offense, is not a right. The court will decide if the bail has to be granted. However, the court may still grant bail in some situations. For example, let's say the accused person is a woman or child, or let's say there's a lack of evidence, the trial has not been completed, if there's a delay in filing the FIR, or let's say the accused is seriously ill, then during such time, during such cases, bail can be granted. Bail can be granted. So non-bailable, which means serious crimes serious like murder, rape, bailable. Non-serious like robbery, theft. Now, what did the Supreme Court say, or what did the Supreme Court observe with respect to bail? Now, in one of the cases, that is the state of Rajasthan versus Balchand in the year 1977, the Supreme Court laid down important principle about, about granting bail. It emphasized the presumption of innocence. Presumption of innocence. What does it mean? It states that everyone must be treated as innocent until proven guilty. I have accused a person of, let's say, murder. Until the court decides a person will be considered innocent. This is presumption of innocence, which means the court at first will believe a person to be innocent. Presumption of innocence. And only when the prosecution will prove that this person is not innocent, and if the court decides a person is guilty, then the person will be punished. The court also linked this particular case with Article 21 of the Constitution. This is very, very important. This guarantees the right to life and personal liberty. Now, if you detain someone without any clear evidence, this can be seen as violation of Article 21, which means you do not have any evidence and you are simply arresting a person. The Supreme Court held that bail should be the rule and jail should be an exception. Very, very important. What? Bail should be the rule and jail should be exception. The judges are supposed to grant bail to a person. Jail should be an exception, which means a person should be allowed to be given, should be made free unless there's a strong reason to deny. But when it comes to cases like Narcotics, Drugs and Psychotropic Substances Act, or let's say Unlawful Activities Prevention Act, or let's say Prevention of Money Laundering Act, during such or when cases are filed under these laws, this approach may not work. This approach may not work. Narcotics, drugs, case of smuggling, case of terrorism, cases of money laundering. This approach may not work, which means, let's say when a person is accused under prevention of money laundering, that the person has actually laundered money, or let's say person has actually involved in smuggling of drugs, then jail is not a rule. Bail is not a rule, which means a person has to stay in a jail. Has to stay in a jail. The bail will be treated as an exception. For these cases, bail will be treated as an exception. I hope you understood the concept of bail and the provisions under it. Now students, let us discuss the next topic. The next topic is about Consumer Protection Act 2019. Here the Supreme Court ruled that services rendered by the advocates is not covered under the Consumer Protection Act. The court emphasized that the legislature never intended to include professional services such as those provided by the advocates within the Act's purview. Which means you simply cannot, let's say, file a complaint against an advocate under the Consumer Protection Act. Consumer Protection Act. The ruling emphasizes unique nature of the legal profession, which means the legal profession is not as as generalized as other profession. The legal profession is very unique. The question is, so again questions are asked, right? So for example, this is an act, question can be asked on this act as well, right? Like it is asked on the geographical indication of goods act 1999. So question on the acts are often asked in the examination. Question is, this is what we need to understand. Why services of advocates cannot be compared to other services? This is what the Supreme Court said. That's the reason the Supreme Court said that you cannot file a complaint against advocates under the Consumer Protection Act. So why is it that the legal profession of advocates is cannot be compared with the other services? Why it cannot be compared? Here the Supreme Court actually gave certain observation, and what is the observation? Let us discuss. The Supreme Court has made it clear that what advocates do is not the same as the services offered by, let's say, regular businesses. One big reason what the Supreme Court said is the nature of work. Nature of work, which means becoming an advocate. It takes years of, let's say, study. It requires special training and a deep understanding of the complicated laws. Their job isn't just routine work. It requires a lot of thinking, careful judgment, and also, let's say, expertise in within the specific area. That's why it's very different from what we normally think of, let's say, a business or let's say or a trade. These are regular business. Let's say you're trading in a business, trade or business. Legal profession cannot be cannot be thought on the lines of the other businesses or other services. And then another reason the Supreme Court gave a special trust between an advocate and a client. Special trust, that is the fiduciary relation between an advocate and a client. Now, this relationship is actually built, the relationship between an advocate and a client is built on confidence. And the advocates must follow their client's instruction very carefully. They cannot take decisions or let's say make compromises in the case without the approval of the client. They have to listen to what the client says. This strong sense of, let's say, responsibility makes legal services very different from, let's say, the other services like, let's say, the consumer service. The Supreme Court also said that in legal matters, the client is more involved than in, let's say, other services in the legal matters. Now, the client helps decide how the case should go, which steps should be taken, and whether to accept or, let's say, reject certain strategies. In the most regular service, the service provider, let's say, handles everything without needing constant support. But in legal services, the client plays a key role throughout. This level of involvement is, is another reason why legal work cannot be compared to typical business work. Let's say the consumer work, consumer service. This is what the Supreme Court reasoned, and that's the reason the Supreme Court said that complaint cannot be filed against an advocate under the Consumer Protection Act. So what does the Consumer Protection Act say? Now the section 2, subclause 42 of the Consumer Protection Act, it states that the term service includes almost all kinds of service made available to the customers or let's say the users. But it excludes services provided under a contract of personal service. Contract. Services made under a contract is exempted from the Consumer Protection Act. This is important because the Supreme Court has ruled that the relationship between a client and an advocate falls under the contract of personal service. In the previous discussion, in this part, I discussed the relationship between a client and an advocate as understood by the Supreme Court. And so, this relationship actually comes under the contract of personal service, which is exempt from the Consumer Protection Act. Therefore, the services given by the advocate do not fall within the purview of the Consumer Protection Act. This means that the clients cannot file consumer complaints against advocate. This is the essence of the topic. Now, there are few judgments discussed related to the case, right? For example, in the Indian Medical Association versus VP Shanta case. In this 1995 case of Indian Medical Association, the Supreme Court held that the doctors and medical professionals could be held accountable under the Consumer Protection Act. The doctors and the medical professionals, let's say if there's any delinquency, deficiency in their services. Now, this ruling of the Supreme Court in the year 1995, it actually opened the door for including other professional services, let's say like the legal profession as well. However, the current ruling of the Supreme Court suggests that such decisions may need reconsideration, particularly for professions that actually involve personal trust between client and, let's say, and an advocate. Then again in the 2007, the National Consumer Dispute Redressal Commission, the Supreme Court ruled that the services provided by the lawyers did fall under the Consumer Protection Act 1986, but that decision now has been ruled by the current Supreme Court judgment, which states that the legal profession like the advocate do not fall within the scope of the Consumer Protection Act. I hope you understood the essence of the Supreme Court judgment. This brings us to the next topic, which is the Supreme Court's curative jurisdiction. Now here, what is this curative jurisdiction part of the Supreme Court is something that we need to understand. Now, powers of Supreme Court, questions about the powers of Supreme Court, they are often asked in the examination as it was asked in the year 2014. Right? This pertains to the power of the Supreme Court. So, first and foremost, let us try to understand what is curative petition. What is curative petition? What is curative petition? Now, a curative petition is a solution, is a legal solution used when a person believes that a serious injustice has occurred even after the Supreme Court has rejected a review petition. Let's say, for example, Supreme Court has given a judgment. Supreme Court has given a judgment. Against the Supreme Court judgment, you can file a review petition. Even after that review petition gets exhausted, you have other option, which is the curative petition. When a person believes that an injustice has occurred even when the review petition has been rejected, which means first step is Supreme Court gives a judgment. You file a review petition against the Supreme Court judgment. Even if this gets, let's say, sidelined, then you have the option of curative petition. In general, a Supreme Court judgment can only be questioned through a review petition, which is allowed only on a limited procedural grounds. But in very exceptional cases, when there has been a major Let's say miscarriage of justice, the court permits a curative petition, and this type of petition, the curative petition, it acts as a safeguard to prevent the misuse of the legal process and to correct extremely unjust outcomes, or whenever the Supreme Court understands that there's a grave injustice. Now these petitions are usually decided by judges in their chambers, though an open hearing can be allowed if specially requested, but usually the decisions are not held in open door, or let's say open discussion. It happens in the chambers. Now which are the criteria on the basis of which curative petition can be admitted or rejected? Supreme Court judgment, review petition, and then which are the criteria? There has to be criteria, right? There has to be criteria on the basis of which it will be decided whether curative petition has to be accepted or rejected. Now, please remember that the Supreme Court may accept a curative petition when, let's say, on very specific and serious conditions are met. One such is violation of natural justice, like when a party was not heard before a decision was made. When a party was not at all heard and a decision was made. This is one. And another valid ground is apprehension of bias, that is partiality by a judge, especially if there is a failure to disclose relevant facts that could have affected the outcome of the judgment. These criteria ensure that curative petitions are not misused and are used in only exceptional situations. Two grounds: violation of natural justice. The second one is bias. Right? Now, there are some examples of curative petition. These are the two cases that we will discuss. One is the Union of India versus Union Carbide case. The other one is Navneet Kaur versus State of NCT of Delhi in 2014. Now, in the Union of Carbide case, which dealt with the Bhopal gas tragedy, the central government filed a curative petition in the year 2010, asking more compensation be given to the victims. In the year 2023, that is 13 years later, a 5-judge bench dismissed the petition. Who filed the petition? Central government. Central government argued that the company, Union Carbide company, should pay more compensation to the victims, and so it filed a curative petition. But the Supreme Court rejected the petition, stating that the compensation awarded is sufficient. Another example is the Navneet Kaur was a state of NCT of Delhi. Now, in this case, a death row convict filed a curative petition arguing that her long wait for mercy petition and a mental health condition should be considered, which means she was actually awarded death penalty. Death penalty, and that's the reason she requested for a mercy petition. Why? Because her mental health condition was not good. So she requested, or she filed a mercy petition. Now, in this case, as the mercy petition was not granted to her or was not accepted, this person, her counsel, actually filed a curative petition, and the Supreme Court accepted the petition, and the Supreme Court commuted her death sentence to life imprisonment. Death sentence was awarded initially, now it was commuted to life imprisonment. This case showed that curative petitions can actually bring meaningful change in cases especially dealing with the human rights and the life and death decisions. Life and death decisions. Now, which are the guidelines? Which are the guidelines to file a curative petition? Now, one, to file a petition, or let's say to begin the process, the petition must be accompanied by a certificate from a senior advocate. Now, this is a designation given by the Supreme Court. This petition must be signed by a senior advocate, and this senior advocate should confirm that there's a strong legal reason to consider or accept the curative petition. Then the petition is then circulated to a bench, 3 senior most judges of the Supreme Court, along with any judges who gave the original judgment if they are available. If they are available. Now, if the majority of these judges agree that the matter deserves a fresh hearing, a hearing is scheduled before the same bench that delivered the original judgment. Now, at any point, the Supreme Court has the power to appoint a senior advocate as amicus curiae, that is, friend of Supreme Court, to assist in reviewing the case impartially. And the judges find the petition is baseless, or let's say an abuse of the curative petition process, they may impose a penalty, a fine on the petitioner who filed the curative petition. And the Supreme Court clearly said that the curative petition should be treated as extremely rare. It doesn't mean that every time you file a curative petition, it should be treated as extremely rare and must be examined with great care so as to protect the integrity of the judicial system. Integrity of the judicial system. Now, this, as I told you, these are the three types of extraordinary power. One is review petition, curative petition, and special leave petition. Now, you can read this, but let us try to, understand the difference in short. Now, see, if a judgment is passed by the Supreme Court, you will understand the difference with the explanation that I'll explain. The Supreme Court is passing a final judgment. The first available remedy is the review petition. This review petition is under Article 137 of the Indian Constitution. It allows the court to reconsider its own decision if there is, let's say, an error or let's say new evidence is found. This petition must be filed within a limited time frame after the judgment is given, especially the limit is 30 days. Now, Supreme Court has given a judgment, review petition is filed within 30 days, and let's say the review petition is dismissed. And if the petitioner still believes that there is a serious miscarriage of justice, they have the power to file curative petition. This is allowed in only extremely rarest of rare cases to prevent miscarriage of justice. There is no constitution, it is not mentioned in the constitution. The curative petitions, right, it was actually introduced by the court in one of the cases in the year 2002. So when the final judgment from the Supreme Court, the correct sequence is first to file a review petition, followed if needed, then a curative petition. Which means when it comes to Supreme Court judgment, review petition and curative petition. Then what is special leave petition? Now, if a judgment is passed, let's say by a lower court or let's say by a tribunal. Now, if a decision comes from the High Court or let's say any tribunal, the party can approach the Supreme Court through special leave petition under Article 136 of the Indian Constitution. This gives the Supreme Court the power, the discretion to accept it or reject the, special leave petition. And no specific grounds are actually required. The special leave petition, right, it allows a party to appeal a lower court judgment before the Supreme Court, or let's say appeal a judgment given by the tribunal directly before the Supreme Court. And this is actually done in matters of public interest, or let's say in the matters of justice. And once the Supreme Court hears the matter through special leave petition and gives the final verdict, then the same review curative process is applicable if required. Now, here Supreme Court hasn't given a judgment. Post the filing of this petition, if it is accepted, Supreme Court gives a judgment, then the option is review and curative petition is the last option a petitioner would ever have. Beyond this, there is no solution, there is no scope. I hope you understood this topic. Now, this topic talks about the judgment Supreme Court gave with respect to the VVPAT. So here in this topic, so again questions, on the powers of Supreme Court are often asked in the examination. Now here we'll try to understand the concept of EVMs and VVPAT. What exactly is EVA? What is EVM and what is VVPAT is something that we'll understand. Now what is EVM? I have no idea if you have ever voted in any of the elections in our country. Anyone who has voted in the elections of a country, whenever you had been to a polling booth, you must have seen two machines. One is EVM, the other one is VVPAT. So EVM stands for electronic voting machines. It's a device used to electronically record votes. There are two parts. One is the ballot unit. This ballot unit is a unit that will actually cast the votes casted by the voter. You have to press a button on this ballot unit. And then besides the ballot unit, there's a control unit which actually stores and counts the votes. Two, one is the ballot unit, the other one is the control unit. Ballot unit and control unit. Ballot unit, you press the vote, you cast your vote, the control unit will, let's say, store the vote so that it can be used for counting. The EVMs were first used for the first time in the 1982 elections in Kerala. Now, this EVMs they replaced the traditional paper ballots and became the standard voting method across India by 1998. What is ballot paper? It's a simple piece of paper used to mark a voter's choice in an election. But by 2003, EVMs were used in all the state and by-elections. And in the year 2004, the Election Commission of India made their use compulsory for the Lok Sabha elections as well. So you had to remember the date. So EVMs provide, many advantages, such as, you can quickly count the voting. It actually reduces the human error. It eliminates the invalid votes, and it also lowers the chances of vote capturing by restricting the voting speed to about, let's say, 4 votes per minute. 4 votes per minute. This is the electronic voting machine. Then what is VVPAT? VVPAT refers to voter verifiable paper audit trial. This was introduced post the EVM's introduction to make the voting process more and more transparent as well as reliable. In order to, let's say, uh, in order to make the election system more transparent, the VVPAT system was introduced along the EVM to generate a paper slip for every vote that the voter cast. So once a voter casts, there will be a slip that generates. This slip contains the name and symbol of the selected candidate and is visible to the voter through a transparent window for about 7 seconds before, let's say, falling into the sealed box. Which means, let's say, whenever I vote, press a vote for 7 seconds, on this VVPAT machine, a slip generates. This slip will show the, let's say, the symbol and the name and symbol of the selected candidate. Name and symbol of the selected candidate, which means this is to verify whether the vote that I have casted is correct or incorrect. It allows to confirm that the vote has been accurately recorded. The VVPATs were first introduced in India during the 2014 Lok Sabha elections to increase the trust in the voting process. But many people actually challenge the use of EVMs and VVPAT because the petitioners, right, the ones who criticize the EVM, they felt that this system can be tampered. This system can be tampered. That's the reason the Supreme Court, issued some directions to the Election Commission of India. It issued 2 key directions and few suggestions to the Election Commission of India to enhance the security and transparency of the voting system using the EVMs and the VVPATs. Now, the directions were actually meant to make the electoral process more transparent and reliable. What was the first direction? The first direction that was given by the Supreme Court to the Election Commission of India was to seal and store the symbol loading units for 45 days. For 45 days after the results for an election is declared. You have to store the symbol loading units for 45 days. Now, what is symbol loading units? The symbol loading units, right? It's a memory device used to upload the symbols of contesting candidates into the VVPAT machines. It is first connected to a, let's say, computer for loading the symbols and then linked to the VVPATs. Now, storing the symbol loading units securely allows future checks if any doubts are raised after the election. Let's say after the election, a person who came second wants to actually challenge the result. That's the reason the second direction issued by the Supreme Court is the court allowed candidates who finished in second or, let's say, third to request technical verification of the EVM to ensure whether the counting has been done accurately. Now, if these candidates believe that there was tampering, they can make a request within 7 days of the declaration of the results. Once a complaint is made, then a team of engineers will then check the burnt memory in the EVM's microcontroller to see if there is any tampering which has occurred. And the cost of this process is actually borne by the requesting candidate. And let's say if tampering is to be found, then the amount will be refunded back or refunded to the petitioner. And with respect to suggestion given by the Supreme Court, right, it gives suggestion to improve the VVPAT slip counting process. At present, these slips generated on the VVPATs are counted by, let's say, hand. The court suggested that the ECI may consider using counting machines to handle these slips more quickly and accurately. It also recommended uh, printing a barcode on each VVPAT slip to allow the easier, let's say, or to allow the counting of votes, which could be easy. This is what the Supreme Court suggested. I hope you understood this concept, you understood the difference between EVM and the VVPAT. This brings us to the last topic of the day, which is the arbitration in India. Now, questions on arbitrations have been asked in the examination in both pre as well as mains, right? So, let us first understand what is the concept of arbitration. What is arbitration? Arbitration actually is a form of alternative dispute resolution. It's a form of alternate dispute resolution where two or more parties they choose to settle their disputes outside the regular court system. Outside the regular court system. See, usually the cases are settled inside the court, but here the parties have decided to settle the case outside the regular court system, which means instead of going to the court, the parties involved in a case, they agree to present the case, let's say, to a neutral third person, and this neutral third person is referred to as arbitrator. Is a neutral third person. This arbitrator, right, who actually belongs to field of law, he then listens to both sides. He examines the evidence and then finally gives a decision. This decision is referred to as an arbitration award. Now the decision given by the arbitrator or the arbitration award is binding on the parties. They have to abide by it. Now this method wherein instead of going to the court, you are actually settling the matter outside, is especially useful when it, especially useful. Why? Because it actually avoids the delays and, let's say, the process of going to the court and then, that tariq continues. The question is, why arbitration is needed in India? We know that there's a growing need of arbitration in India. Why? Because of the massive backlog of cases. Now, as per the national judicial data, 5.02 crore cases are pending across different, different hierarchy of the Indian courts. And this overload actually puts pressure on the justice delivery mechanism, and this actually leads to delays in the resolution or, let's say, dispensation of cases. And that's the reason arbitration, it's an alternate dispute resolution which actually offers a quicker and rather a more efficient way of resolving disputes. This can actually reduce the burden on the courts and also ensure the justice delivery system is as efficient as it should be. Now, talking about the benefits of arbitration, now what are the benefits of arbitration? See, one of the biggest benefits of arbitration is that it keeps the court involvement to minimal. The court involvement is actually minimized. The process is more private and informal. It is not formal. It makes it less intimidating for the parties, because when you hear courts, it's actually very fearful, that is intimidating. The second benefit is that it is cost effective, which means it avoids the high expenses usually associated with the long legal battles which continue for years after years. Then arbitration is also known for faster resolution, quicker resolution, as time limits are usually set for decisions in the arbitration cases. It helps party to resolve the disputes more quickly. Another advantage is specialization. It doesn't mean that the arbitrator is someone who is not, not belongs to the field of law. Parties can choose an arbitrator who has specific expertise in the subject matter of the dispute. And this actually leads to better informed decision making. Now, legal framework for arbitration in India. Now, the arbitration is also backed by law in our country. It is governed, the arbitration process in our country is governed by the Arbitration and Conciliation Act of the year 1996. This law is actually based on the 1985 United Nations Commission on International Trade Law model on the international commercial arbitration. This law is actually based on this commission, right? And also this law is based on this commission as also the rules framed under this law of 1976. This is what you need to remember. Now, to make the process faster and more efficient, a major amendment was made in the year 2015. This amendment actually focus on uh, speeding up the contract enforcement. It improves the recovery of monetary claims as well as it reduces the number of pending cases in the court. Now, please remember that India has also set up dedicated institutions to promote arbitration. For example, we have the New Delhi International Arbitration Center. This was established in the year 2019 through the Arbitration Act. Now, this arbitration center, it aims to promote international institutional arbitration and also offers modern facilities for, let's say, handling arbitration cases in India. Another institution that we have in our country is the International Center for Alternate Dispute Resolution, which was set up in the year 1985. Again, this also works to promote all forms of alternate dispute resolution, and it also helps to reduce the workload, or let's say to reduce the backlog of cases in the judiciary. Which essentially means that arbitration is alternate dispute resolution. Instead of going to the court, you actually settle the matter outside the court. And then we have a legal backing known by the Arbitration and Conciliation Act. Now, which are the types of arbitration in India? We'll discuss the types of arbitration in India. Now, see, there are mainly two types of arbitration, right, followed in India. One is the ad hoc. One is the ad hoc arbitration, the other one is institutional arbitration. Now, in the ad hoc arbitration, the process is carried out without the involvement of any formal institution. No formal institution is involved. The parties themselves, right, or let's say the arbitral tribunal decide the rules and procedures to be followed. Either the parties or let's say the arbitrator. Now, this is the most commonly method used in our country, which the ad hoc tribunal. On the other hand, we have the institutional arbitration, which is actually managed by the recognized arbitration body that follows its own set of established rules and let's say the procedures. In India, the institutional arbitration is not widely accepted. Why? Because there is lack of awareness. This absence of law, this absence of strong legal structure, and also there's hesitation from the government bodies to use it. Now, currently, there are more than 35 arbitration institutions in India. It includes both international as well as the domestic centers, especially those run by the public sector units. Right? So, this is the most widely used method in our country, ad hoc arbitration. Either the arbitrator sets the rules or the parties involved set the rules. This is more institutional, this is more formal, this is more informal. Now let us also discuss the 5 types of alternate dispute resolution. The first one is conciliation. Conciliation, which essentially means that it involves a neutral third party who communicates with the disputing parties, with the parties involved, and helps them to exchange information and settlement options. It is more flexible than arbitration, and the main aim is to encourage an agreement without imposing a decision, to have an understanding between the parties. This is what we understand by the term conciliation. Now we understand what is negotiation. Now, negotiation is a method, right, where the parties and the legal representatives try to resolve the dispute directly among themselves. Here, the legal representatives are also involved. The process does not involve any neutral third party as it was involved in the conciliation, and it is the informal, most informal of all the ADR methods. Then third is mediation. Now, mediation, which means someone is mediating, is a highly flexible process where a neutral third party, he assists the disputing parties in reaching an agreement, which should be, let's say, voluntary agreement. It can be used at any stage of the dispute, and it's particularly useful when parties want to preserve the relationship and do not worsen it. This is the another used ADR mechanism. Then we have arbitration. This is purely formal process. This is purely formal process where a neutral arbitrator is appointed to listen to both the sides. Then the neutral arbitrator, he reviews the evidence and issues a binding decision, which is referred to as arbitration award. It is more formal, that is more structured, and more formal, more structured than the other previous 3 ADR methods. And the last is the collaborative law. Now, this collaborative law, right? This collaborative law is a process. It's a process where both parties are represented by lawyers who are actually trained. The parties agree in advance not to go to the court and to work together in good faith so as to resolve the dispute through cooperation. So these are the 5 types of ADR mechanism, and this brings us to the end of the 9th topic of the day. Students, I expect that you have understood each and every topic that we have discussed today. Any topic, any point that you haven't understood, I request you to please ask in the comment section. Again, students, I request you to please download the notes of the topics that we have discussed from the link given in the description box. I keep on emphasizing the importance of revision again and again. Why? Because it is very important to revise all what we study every day. Make sure you're revising the points that we're discussing, because 95% of the points that we discussed in today's lecture or every day, they can be asked directly or indirectly in the examination. So make sure you're revising by downloading notes of the notes through the or mentioned in the description box. On this note, I'll call it a wrap. Before I call it a wrap, please, I request you to please hit the like, subscribe, and share it to as many needy aspirants. Thank you so much for watching.